Hi, this is Lisa DeMonte with mylegal.com, and we're here at the Ronald Reagan Building in Washington, D.C. for the Masters Conference, Day 1, October 4th, 2010. With me is Chris Dale, who's a former commercial litigation partner and eDisclosure consultant. Chris runs the eDisclosure Information Project, and we're delighted to have you with us this afternoon. Chris, thanks for joining us. Chris, you were just part of a panel with Craig Ball and others discussing ways to manage the volume of key facts and how best to make fast decisions based on solid knowledge and case understanding. There seems to be a difference of opinion about what early case assessment is, when it begins. Tell us, what is your definition of early case assessment?
I resist the hunt for a definition. The battles that go on, my ECA is earlier than your ECA. I don't think that matters so much as the idea that early means before a stage where significant expense is going to be incurred. Whatever stage you're at, you need to be constantly assessing what you're doing, and as early as possible, in a way that's going to save money later. The most important bit of the assessment, so far as I'm concerned, is what goes on in your brain. I have a reiterated expression I use to the effect that the most important technology that we have is what lies between your ears. And that tends to be overlooked in the technological battle, people polishing lovingly their data without often having regard to the objective that their clients want to achieve, or to the simple question, what matters here? What's most important? Here we have a luxury in the UK that you have less in the US, to this effect, that the giver gives the documents that he thinks are disclosable, as we call it in the UK. There isn't a battle over requests before you start. That allows, we also have, should I say, a greater flexibility for, if the lawyers would only care to use it, to decide for themselves what is the appropriate level of the search. They need to develop the skills to argue that, to persuade opponents that their level of search is the appropriate one. But it's potentially an easier way of doing things than the battle of the requests that you have over here.
Chris, you mentioned just one of the many differences in the way eDiscovery is handled as between the US and the UK. Tell us a little bit more about any other differences, and particularly with reference to the electronics documents questionnaire that you referred to in the panel discussion.
One difference, which I didn't mention in the panel that we've just finished, is that we don't have a concept of spoliation in the same way as you do in the US. Arguments about whether people have disclosed everything they ought to have disclosed and whether the judge has got everything that he wants take place in a rather different context. For example, the judge decides at trial whether you have deliberately destroyed documents or whatever. We don't have discovery battles about discovery, which seem to me anyway to consume so much energy over here. The electronic documents questionnaire to which you refer is a new development that came in on the 1st of October, and I was amongst those who was responsible for drafting it. Its purpose is to allow parties to exchange information in a formal, structured way by filling in a form. Only in appropriate cases, those cases that have enough electronic documents to warrant it, to enable cooperative discussions to take place. And if those discussions don't result in a sensible conclusion, to take it to the judge in the same structured manner so that he can make a decision based on actual knowledge. Otherwise, the parties are expecting judges to make decisions in the dark. At least if they have the discussions based around this questionnaire, at least one of them is likely to get the answer that he wants out of it all.
Very interesting indeed. I think the US may need to take some further cues from the UK in terms of how they're handling some of this information. Chris, one final question for you. In the panel discussion, Craig talked about his dream was to have a QuickBooks type solution for electronic discovery on every lawyer's desktop. Is that a pipe dream?
It may be. The time will come, undoubtedly, that the software becomes both much more intuitive than it is, and it's getting that way, as well as affordable and more within the reach of more ordinary lawyers, as it were, as opposed to those who are highly technical. I think we will see that. I'm not sure that we'll see it in the next 5 years, but we will see it.
Chris, thank you very much for joining us today. We appreciate your time and your input.
My pleasure.
Thank you.